everyone. In the last class, we have discussed about the chapter 6 of the Indian Contract Act, which speaks about the consequences of the breach of the contract. Okay. And under section 73, we have discussed the compensation for the loss or damage which has been caused by the breach of the contract. Okay. So when we're talking about the when we're talking about the compensation for the loss or damage that has been caused due to the breach of the contract, under that we have discussed that when there is a contract and the contract is broken, the contract is just the party who is the promiser or who is the promisee, any of the party itself is unable to continue with the terms and conditions of the contract, or is unable to fulfill the terms and conditions of the contract. In that circumstances, the party, if any of the party from the contract is breaking the contract or the contract is broken by any of the party itself, then the party who breaks the contract is liable to pay the compensation to the another party for the damage or loss occurred. Okay, that is why we have already discussed under section 73 of the Indian Contract Act in the last class. Okay, so just 1 second. So let me summarize it in a better way, like what this act actually speaks about. So when we have talked about the section 73, we have discussed that if there is any kind of the losses that is called as the remote loss, that means the loss is not direct in nature, or the loss is not directly occurring due to the breaking of the contract, then in that circumstances the party for whom the loss has been occurred, he or she is not liable to pay compensation to the other party for the loss occurred. Okay, so if the loss or damage is genuine and that is practically happening due to the non-performance of the contract. For example, we have made an agreement that you will build a home for me, you are going to build a house for me in next 6 months. Okay, so according to the contract, what I did, I for example, I was staying in an apartment before as the rented property. Then I have given you a certain amount of money to build my home. Okay. I have paid you the amount of 50 lakh that keep this money, build a home for me, and I have also provided you all the necessary goods that you need to build a house. And I ordered you or I requested you to build a home for me. You said okay. So trusting you, what I did, I have left my previous apartment or previous rented house where I was staying. But after 6 months, when I'm seeing the result, you are telling me that no, I am unable to complete the house in 6 months. I'll need more 6 months to complete the house. Then what is happening over there? I have already left my rented property where I cannot go back to there again. Okay. And here also, you are unable to build the house for me. So, who is suffering the loss over here? That is me. So, I have to take another rented house or do something else to for my own um, residence. Okay. So, in these circumstances, when you are unable to do your performance of the promise and due to your unavailability or due to your negligence to do the performance, I am here suffering the direct loss or damage. That is why here this is your responsibility to pay me the damage or the loss that I have got due to your non-performance of the contract. Got it? And if the nature of the loss is remote, what do you understand by the remote losses? That means the loss which is not direct in nature. Okay. For example, there was an agreement between us, but you were unable to perform the agreement to me. Okay. So when you are doing the non-performance of the agreement, or you are unable to perform the agreement in a proper manner, what is happening? That I am suffering the loss. Okay. First, this is the first criteria. The second thing, due to the non-performance or due to your negligence to the work, I am just dissatisfied from you. Okay, I am mentally disturbed or I am mentally dissatisfied from you. So what I am doing, I am just getting angry on you that no, you are not performing your duty and all. And with the frustration, I am going somewhere or I am driving. Okay. So what is happening while driving due to my anger or due to my frustration, I am meeting an accident and my car is getting damaged. Okay. So here I am suing you to pay me my whole medical expenses of 20 lakh or 15 lakh of the rupees that is caused due to the frustration, and that frustration has been arised due to your non-performance of the contract. So tell me, are you responsible over here to pay me the damage of the losses of the car and my physical health? The answer is no. Here, this loss is totally remote in nature. This is not the direct loss. This is called the remote loss. Okay. So, how is it? When you told me that you are unable to perform the contract, you are unable to build a house for me at that moment, the loss I am facing, that I have to take another rented house, I have to stay somewhere else. So, whatever the losses I am facing in that sequence, taking up the new house, searching new place to stay, all this compensation you have to pay me, no doubt. For example, I am taking another home for rent that is up to for the 6 month, and that is costing me 1 lakh of the rupees or 2 lakh of the rupees the rent of the house. Okay, so you have to pay the whole amount of the compensation of 1 lakh or 2 lakh or 3 lakh, whatever it is, or the amount of the losses, and you have to compensate me for my losses thereon. Okay, but as I am frustrated on you, while driving I made an accident. That is not the result of the loss or damage occurred due to the direct effect of the act. That means due to the direct negotiation by you or due to your negligence not to build my home, this is not the cause of the accident. My negligence to drive or my speed driving or whatever the reason may be, that is the reason of the accident. So here, if the nature of the loss is remote in nature, that is, this is the indirect loss, then you are not liable to pay for this kind of the remote or indirect losses, but you have to pay for the direct losses, which is direct are resembling in nature. That means you have to pay for something, you have to compensate for the something which is arising from the direct act of the parties. Okay. Then in the third point we have discussed about the obligations resembling the contract. Okay. So in this case, we have discussed where obligations similar to contracts are established, like quasi contracts. If one party fails to fulfill this obligation, the affected party can seek compensation as if there were a contract in place. So, what does it mean? When there is the absence of the contract, I mean, there is not any practical or direct contract is present over there, but the act or the situation is as like it is a contract, that we might call it as the example of the quasi contract itself. For example, I have also explained in the last class to you that I have explained to you in the last class itself that when, for example, there is a delivery to my home, okay, there is a food order that has been delivered to my, that was supposed to be delivered to my neighbor's home. To my, there is a person living in my neighbor. He or she has ordered certain kind of the food, but the delivery boy, instead of delivering food in his or her house, mistakenly delivered the food in my house. Okay. So while there is the mistake in the delivery of the food item which has been delivered to me, what I did, I received the product or I received the food item, and instead of calling the restaurant or sending it back, what I did, I ate the food. ओके, थोड़ा हिंदी में इसको समझते हैं, अच्छे से आप लोगों को समझ में आ जाएगा। जैसे कि मान लो मेरा पड़ोसी मेरे घर के पास कोई एक रहता है, दैट पर्सन हैज ऑर्डर्ड सम काइंड ऑफ द फूड, उसने कुछ खाना ऑर्डर किया है। तो खाना किसने ऑर्डर किया है? उन्होंने किया है। खाना डिलीवरी किसको होना चाहिए? उनको होना चाहिए। बट डिलीवरी बॉय यहाँ पे क्या किया, मिस्टेकनली जो खाना मेरे पड़ोसी के घर पे डिलीवरी होना चाहिए था, वो खाना लाके मेरे घर पे डिलीवरी कर दिया। जब डिलीवरी बॉय ने मेरे घर पे खाना डिलीवरी कर दिया, तब क्या होगा? आई वॉज सपोज टू रिटर्न द फूड टू द डिलीवरी बॉय। यहाँ पे मेरा रिस्पॉन्सिबिलिटी क्या बनता है कि ये खाना तो मैंने ऑर्डर नहीं किया, इधर मैं इसका पैसा दे देती हूँ, नहीं तो मैं इस खाने को वापस कर देती हूँ रेस्टोरेंट को। बट व्हाट आई डिड, आई एट द फूड, मैंने उस खाने को खा लिया। ओके, सो व्हेन देर इज द यूटिलाइजेशन ऑफ द फूड बाय माई सेल्फ, जब मैंने खाना खा लिया, उसके बाद आई एम बाउंड बाय द लॉ ओवर हियर टू पे द अमाउंट ऑफ द फूड। खाने का जितना भी अमाउंट है, आई एम बाउंड बाय द लॉ एंड ऑर्डर टू पे इट। यू मे आस्क व्हाई? यहाँ पे तो मैं अपने ऑर्डर किया भी नहीं था। हाँ, यहाँ पे मैंने खाना ऑर्डर नहीं किया था, बट द पॉइंट इज हियर द circumstances is that I was not supposed to enjoy the product or enjoy the goods which was not belonging to me. Even after knowing this, I enjoy the benefit from that specific goods. That is why I am raising an obligation over here to do the payment for that specific enjoyment. जैसे कि आप कोई दूसरा सामान ले लो, फॉर एग्जाम्पल मेरा एक दोस्त ने, उसका एक एक अच्छा सा कोई भी सामान है, वट एवर द हाउस होल्ड थिंग्स, फॉर एग्जाम्पल टेक इट एज ए माइक्रो ओवन. ओके, वन ऑफ द माई फ्रेंड has ordered a micro oven for himself or herself. So the micro oven is mistakenly delivered to my place instead of my friend. Okay, so what I did, I received the micro oven, and instead I neither informed my friend about the receiving of the order, or neither I paid for it. The payment has been done already by my friend, but I received the product and I started using the micro oven. Okay. So here, when my friend got to know about this, she is liable to get the amount of compensation or the full money or the full price of the micro oven from me, because she is the person who has paid for the good. I was not the one who has bought the product, but I am enjoying the benefit from the product. That is why I have to compensate my friend for the unauthorized enjoyment of the property. Okay. And the last point, it speaks about the mitigating losses. The passage notes that when calculating compensation, the means of the mitigating or remedying the loss should be considered. This means if the injured party could have reasonably take steps to lessen the impact of the breach, this should be factored into the procedure of the compensation. Okay. So this is all we have discussed in the last class. Proceeding to the next, we are going to discuss section 74. Yeah. And section 74 speaks about compensation for breach of the contract where penalty stipulated for. Okay. So what does this provision exactly means? Okay. Under section 74, it speaks about when there is the damage due to the breach of the contract, then the compensation must need to be paid. And if there is the lacking of payment of the compensation, then the sum or the penalty also need to be paid due to the delay in the payment in the compensation process. Okay. So let's understand this one by one. First, just let's read it out. When a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty stipulated for. Okay. So the first point, it says when a contract specifies a particular sum as payable upon the breach, the injured party can claim compensation up to this amount regardless of whether they can provide the actual loss or damage. However, the compensation awarded must be reasonable and cannot exceed the amount named in the contract. Okay. So what does it mean? For example, there is a deal between you and me. There is the agreement between you and me, and the agreement is if you are failed to perform the contract, you have to pay the compensation of 2 lakh of the rupees. And even you see, this kind of the contract are more available nowadays. There are a lot of examples of this. Uh, you might know that you are entering into the job. There is the agreement you have to do whenever you are entering into any kind of the corporate jobs or technical jobs. Before entering into the job, you have to go through a official agreement. Okay. So what is mentioned in the agreement? It is clearly mentioned in the agreement whenever you are entering into the agreement that you have to serve the company for the minimum period of 1 year. Before 1 year, you cannot leave the job. And if you are leaving the job, then you are you have to pay the compensation up to the amount of 1 lakh rupees or 2 lakh rupees or anything like that. Okay. So here this is the kind of the contract which is stipulating or which is providing, which is figuring out that what is the exact amount of the loss you have to recover if you are breaching the terms and conditions of the contract. And this kind of the contract are very specific in nature. There are a lot of kind of contract you must have seen that if you are unable to do this work, then you have to pay the compensation of 50,000. If you are unable to do this specific kind of the stop, then you have to pay the compensation up to this amount. So this is a stipulated, or this is a pre-scheduled or fixed kind of thing. We already know about this, that if the party is unable to perform the contract, this is the exact amount of the loss or the damage the party is supposed to bear. Got it? So, this is called the sum or penalty clause, and which has been already pre-decided in a contract whenever the contract is made, and when the contract is breached or when the contract is being whenever the contract is breached or whenever the contract is being not performed, then the exact that amount of the sum or penalty must need to be paid off, and no party can excuse from performing his or her duty from paying up that sum or that penalty amount. Got it? So the next provision, let's understand it. And yes, one more thing, the sum or the amount of the penalty must be reasonable and cannot the exceed the amount named in the contract. Okay, that means whenever there is the award of the compensation amount must be reasonable and it must not exceed the amount mentioned in the contract. That means अगर contract पे ये लिखा गया है कि if you are unable to perform the contract, you have to pay the amount of the 50,000 of the rupees, then you have to pay the amount of 50,000 only. This is not the scenario that यहाँ पे contract पे लिखा गया है that if you are unable to perform the contract, you have to pay the penalty of 50,000 rupees and you are paying the amount of 1 lakh of the rupees. The answer is no. ऐसा नहीं हो सकता. कॉन्ट्रैक्ट पे जितना लिखा गया है वो कम हो या ज्यादा हो, उतना अमाउंट का रिपेमेंट बनता है और उतना अमाउंट का रिपेमेंट ही होगा. एंड मोस्ट इम्पोर्टेंटली कॉन्ट्रैक्ट पे जो मेंशन किया गया है ना, वो रीजनेबल होना जरूरी है. जैसे कि अगर मैं बोलती हूँ कि अगर तुम मेरा घर 6 महीने में खत्म करके नहीं दोगे, देन यू आर गोइंग टू पे मी द कंपेंसेशन ऑफ 5 लाख ऑफ द रुपीज. दैट सिम्स रीजनेबल कि ठीक है, मेरा घर बनाना था, आप अगर 6 महीने के अगर घर बना के नहीं देते हो, देन यू हैव टू पे मी द कंपेंसेशन ऑफ द 5 लाख ऑफ द रुपीज. बट अगर मैं यहाँ पे बोलूँ कि अगर तुम मेरा घर बना के 6 महीने पे नहीं देते हो, देन यू हैव टू पे द कंपेंसेशन ऑफ 10 crore ऑफ द रुपीज. इज इट इवन रीजनेबल? द आंसर इज नो. क्योंकि यहाँ पे सिंपल सी बात है कि व्हाट एवर द सिचुएशन ओवर हियर, अगर घर बन भी नहीं पाता है, वहां पे 5 लाख का कंपेंसेशन देना एक रीजनेबल दिखता है, एक वैलिड दिखता है, एक बनता है कि हाँ ठीक है, घर नहीं बना पाए, 5 लाख पेमेंट कर देंगे. बट 10 crore is a very huge amount and it exactly seems unreasonable to pay this much. So here this kind of the contract is unreasonable. Okay, and this kind of the sum which must need to be paid on behalf of the lack of the agreement or lack of the contract is unreasonable and this need not to be paid. एंड यहाँ पे ये मेंशन किया गया है कि अगर कॉन्ट्रैक्ट का टर्म्स एंड कंडीशंस रीजनेबल है तो कॉन्ट्रैक्ट पे कंपेंसेशन देने के लिए जितना भी अमाउंट मेंशन किया गया है उतना ही स्पेसिफिक अमाउंट पेमेंट कर देना चाहिए, भले ही वो ज्यादा हो या कम हो, वो फर्क नहीं पड़ता। इफ इट इज डिल्ट दैट अगर कॉन्ट्रैक्ट परफॉर्म नहीं होता तो वहां पे 10,000 का कंपेंसेशन देना पड़ेगा, तो 10,000 ही देना पड़ेगा। Even if the loss is up to the amount of 50,000, but in the contract it is mentioned that the compensation need to be paid up to 10,000, then 10,000 ही देना पड़ेगा। अगर लॉस 5,000 का हुआ है, 5,000 का हुआ है, बट कॉन्ट्रैक्ट पे 10,000 का डैमेज देने का लिखा है, तो 10,000 ही देना पड़ेगा। दिस इज कॉल्ड द सम और पेनाल्टी क्लॉज, रिगार्डलेस ऑफ वेदर दे कैन प्रूव द एक्चुअल लॉस और डैमेज। ये मैटर नहीं करता कि कॉन्ट्रैक्ट पे जो दोनों लोगों ने साइन किए हैं दैट इज फुलफिलिंग द एक्चुअल डैमेज और नॉट। दैट कॉन्ट्रैक्ट के टर्म्स के हिसाब से ये था, बट यहाँ पे एक्चुअल डैमेज तो और कुछ ही है, सो एक्चुअल डैमेज के हिसाब से पेमेंट करना पड़ेगा, ऐसा नहीं है। इफ द पार्टी वांट्स टू चेंज इन द कॉन्ट्रैक्ट, अगर दोनों पार्टी का कंसेंट रहता है टू चेंज द टर्म्स एंड कंडीशंस ऑफ द कॉन्ट्रैक्ट, तो बात अलग होता है। बट अगर देयर इज द नो कंसेंट ऑफ द पार्टीज टू डू द चेंजेस इन द कॉन्ट्रैक्ट, देन द पार्टी फॉर whom the loss or damage has been occurred, that party is liable to pay the compensation or the sum or the penalty up to a specific amount. Okay. Then the next point, reasonableness of the compensation. What does it speak? Even if a sum is specified in the contract, courts will evaluate whether the amount claimed is reasonable and not disproportionate to the loss suffered. This serves as the safeguard against the excessively punitive damages. Okay. तो थोड़ी देर पहले हमने एक चीज के बारे में बात कर रहे थे, जैसे कि अगर किसी भी तरह का कॉन्ट्रैक्ट फॉर्म होता है तो वहां पे जो भी सॉम स्पेसिफाई किया जाता होता है ना फॉर द लॉस और डैमेज सफर, दैट मस्ट बी रीजनेबल इन नेचर, एंड दिस इज द ड्यूटी ऑफ द कोर्ट टू एग्जामिन द एंड द इवेलुएट द reasonableness of the amount claimed for the loss suffered. ओके, अगर मैं यहाँ पे ऐसा एक कॉन्ट्रैक्ट किया गया है कि अगर तुम 1 साल तक मेरे पास जॉब नहीं करते हो, इफ यू आर लिविंग द जॉब इन बिटवीन द पीरियड ऑफ 1 year, you have to pay the compensation of 10 lakh of the rupees. So tell me, is it even a reasonable reason? Is this kind of the contract is reasonable in nature? The loss or damage which need to be paid according to the contract, is it valid in nature? The answer is no. क्योंकि किसी के पास अगर मैं जॉब नहीं कर पाती हूँ 1 साल से ज्यादा, या 1 साल तक मैं अगर आपके पास काम नहीं कर पाती हूँ, then that is my decision and that is my problem. Yes, you might suffer any kind of the loss due to my non-performance, and if you are taking a compensation of 1 lakh of the rupees, that sounds valid. But if you are taking the amount of compensation or damage from me up to 10 lakh of the rupees, this is totally unreasonable, invalid. This sounds so much. Okay. So the compensation must be reasonable, and this is a safeguard against the excessively punitive penalties. Punitive means the increasing penalty, the penalty which is excessive, which is increasing, which is very difficult to pay. Okay, so this clause protects the person from the punitive penalties itself. Okay, then the next point, this comes about the penalty interest. Okay, so what does it mean? An increase in interest rates from the date of the default may be considered as the penalty. This means a higher rate imposed on the delayed payment could be treated as the penalty under the law. यहाँ पे क्या होता है? For example, there is the agreement between the party. Okay, that if one party is unable to perform the contract, the party is supposed to pay the compensation amount up to 5,000 of the rupees to the another party. But the party is unable to perform the contract. But it is mentioned in the clause that if the party is unable to payment to do the payment of 5,000 of the extra penalty, then he or she has to pay the extra compensation interest for the non-payment. For example, if he is unable to pay the amount of 5,000 rupees in the first month, then he has to pay the amount of 7,000 of the rupees in the second month. The amount of the 2,000 amount of the penalty will be imposed on him. Okay. So this is called the interest in penalty. And if the parties are agreeing to imply the penalty interest, then it can be implied upon the law and order. Then comes exception for public bonds and duties, and under this we have discussed that when there is a person performing the public duty or obligation, they are liable to pay the entire amount specified upon the breach. The rule applies when the breach involves a public duty or act in which public has an interest. Okay. When a person is doing the public service or the person is working as the public servant and that person is breaching his duty, then he or she has to pay the whole amount of the uh, fee or the compensation due to the breach of the public peace or public responsibility. For example, there is a person who is creating the public nuisance, and there is the penalty for the public nuisance is up to 10 to 15,000 of the rupees. So as this person has breached the law and order, this person has breached the public peace, he or she has to pay the whole sum of 10 to 15,000 of the rupees as per se. You may know the traffic rules. Whenever you are not wearing helmet on the road or you are disobeying the traffic rules, then you have to pay the compensation or the penalty. और whenever you are entering into the bail bond, आपने बेल बंड तो किया ही होगा. आप जब विटनेस लेके जाते हो, बेल बंड साइन करते हो, तभी आपको एक कंपेंसेशन अमाउंट देना पड़ता है अप टू द कोर्ट ऑर्डर ऑफ द कोर्ट. So the amount of the compensation that need to be paid in the bail bond due to the breach of the public duty. अगर मैं किसी को मारपीट करती हूँ, किसी के साथ बदतमीज करती हूँ, पब्लिक पीस हैम्पर करती हूँ, तो वहां पे मेरे को एक स्पेसिफिक अमाउंट ऑफ द पेनल्टी लगता है अकॉर्डिंग टू द लॉ. 30,000, 20,000, 50,000. I have to pay a specific amount of the penalty when I am breaching the public peace, and I have to compensate the whole amount of penalty in that specific place. I cannot escape from performing my responsibility to do the payment. Okay. Then the next point speaks about the clarification of the public contracts. So what does it mean? Simply entering into a contract with the government does not mean the contract is undertaking a public duty or is bound to an obligation that serves the public's interest. So what does it mean? It means when someone is simply entering into a contract with a government. For example, I am entering into the contract with the government for a specific role or specific activity. That does not mean that the person who is doing the contract is undertaking the public duty and is bound to serve the obligation up to the public interest. See, if I am entering into the contract with the government with the proper clauses to maintain the public peace, to serve as the public interest, then that is a different thing. But if I am simply entering into the contract with the government for any specific purpose that is not binding me to serve according to the public rule and public interest itself. Okay. So this is all explained under section 74 of the Indian Contract Act. Then comes section 75, and it speaks about the parties rightfully rescinding the contract entitled to get the compensation. Under this, I have already explained you in the last class that, for example, there is a person, there is the bar owner, there is the owner of the theater who has performed with a, who has entered into a contract with a singer, with an artist to perform his song every in 5 days in a week for next 2 months, and the sum was supposed to be paid was 1000 rupees per night. Okay, the singer agreed on this. उन्होंने बोला कि ठीक है, मैं हर रात आके हफ्ते में 5 दिन I'll do my performance. But on the 6th day of his performance, for example, एक हफ्ता उसने आया अच्छे से, he did his work. In the next week, the first day, the 6th day of the performance, he breached his duty. उन्होंने अपना काम नहीं किया. So here, the promiser or the contractor over here, the owner of uh, the owner of the theater has the liability or has the reasonable cause to terminate the contract. And if the party is terminating the contract rightfully or rescinding the contract in a proper way due to the non-performance, then the party is also liable to claim the damage from the person who has breached the contract. For example, here if the artist has breached the contract, if he has not performed the contract, no doubt the contract will be terminated by the theater owner, but also the owner is liable to get the compensation from the singer for the non-performance of the contract for that one night, which is must need to be paid by the singer to the theater owner. This is one circumstances, and another situation I have explained you that अगर यहाँ पे theater owner ने 6th night उनका performance उन्होंने नहीं आया, but 7th night when he came to do his performance, the theater owner allowed the singer to do the performance. Once after the breach of the contract, you are accepting the performance of the contract again. यहाँ पे उन्होंने एक रात नहीं आया, but even after his absence, you are again accepting him to do the performance. आप उनको फिर से accept कर रहे हैं to do the performance. And if this is the scenario, आप अगर उनको फिर से अपना performance के लिए allow कर रहे हैं, then you have no right to breach the contract or you have no right to terminate the contract with the person. आप यहाँ पे अगर एक रात even after his absence, even after his breach of the contract, he showed you the reasonable reason कि मेरा ये दिक्कत हुआ था इसलिए मैं नहीं आ पाया, तो यहाँ पे अगर आप उनको 7th नाइट में परफॉर्म करने के लिए अलाउ कर देते हैं, तो आप फिर से उनके साथ कॉन्ट्रैक्ट कैंसल नहीं कर सकते. यू कैन नॉट रिसाइन द कॉन्ट्रैक्ट विद दैट पर्सन, बट येस यू आर लायबल टू गेट द कॉम्पेंसेशन फ्रॉम दैट पर्सन. आप उनसे कॉम्पेंसेशन क्लेम कर सकते हैं कि मुझे उस रात का जितना मुझे नुकसान हुआ ड्यू टू योर नॉन परफॉर्मेंस आप उनको पे कर दो. बट if I have allowed you, or if you have allowed the person to do his performance again or to continue the performance of the contract even after the negligence to do the performance, then you cannot resign the contract again, you cannot negotiate the contract again. But अगर आपने immediate when the party did the non performance or breached the contract, आप अगर उसी मोमेंट पे contract close कर देते हो, then you are liable or you are reasonably capable to terminate the contract as well as you are liable to get the compensation. But अगर आप उनको परफॉर्मेंस के लिए परमिशन दे देते हो, then you are not allowed to terminate the contract, but you are allowed to rightfully get the compensation from that person. This is what we have explained and we have discussed under section 75 of the Indian Contract Act. Then the chapter 7, it was talking about the sales of goods, but unfortunately, Sales of Goods Act is a special another act right now. This is not no more associated with the Indian Contract Act. It has been separated from the Indian Contract Act, and it has a separate legal existence right now. Then chapter 8 will study that speaks about the indemnity and guarantee. Indemnity means the payment of the damage. For example, if due to my performance of the promise or due to my activity, you are suffering any kind of the losses, then that is called the indemnity. Okay. And when we are talking about the contract of the indemnity, we have understood that a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called the contract of indemnity. We can understand it very simple example. Just like I am promising you that you are if I am unable to perform the contract to you, अगर मेरा यहाँ पे आपके लिए जो रिस्पॉन्सिबिलिटी है, अगर मैं उस कॉन्ट्रैक्ट को सही तरीके से परफॉर्म नहीं कर पाती हूँ, इफ आई एम अनेबल टू परफॉर्म माई कॉन्ट्रैक्ट टू यू, then in that specific circumstances I will pay you the compensation up to 50,000 of the rupees. This is a promise of indemnity, a guarantee of the indemnity by me to you. I am the promiser over here. And as a promiser, this is my responsibility to perform the contract to you, to fulfill my promise to you. But if I am unable to fulfill my promise on my behalf, then here I am reasonably responsible to pay you the indemnity amount, or I am reasonably responsible to indemnify you the guarantee that yes, if I am unable to fulfill my promise, then I am going to pay you the amount of 50,000 of the rupees as compensation. This is called the guarantee of the indemnity. The second situation, the loss occurred by the others. For example, you are starting a new business. One of my friend is investing in your business. You are not trusting my friend for the investment procedure. So here I am assuring you, I am giving the guarantee of indemnity to you. If my friend is unable to fulfill his promise, if my friend who is investing, he is unable to fulfill your demand to follow the terms and conditions or fails to help you out, then in that circumstances, I will indemnify you. I will guarantee you to pay the indemnity of 50,000 of the rupees. तो यहाँ पे दो सिचुएशन मैंने बताया. पहला सिचुएशन मैंने क्या बोला, अगर मैं खुद अपना कॉन्ट्रैक्ट परफॉर्म नहीं कर पाती हूँ, देन आई प्रॉमिस यू टू पे यू द डैमेज और द इंडेमनिटी अप टू द अमाउंट ऑफ 50,000. अगर यहाँ पे कोई तीसरा इंसान है जो आपके लिए काम कर रहा है, that person is unable to do his performance and I am hereby promising you. It doesn't matter कि वो तीसरा इंसान के साथ मेरा कोई रिश्ता है नहीं है, वो मैटर नहीं करता. अगर मैंने आपको वादा किया है कि अगर मैंने या उस इंसान ने अपना प्रॉमिस नहीं पूरा किया, देन आई एम गोइंग टू पे यू द कंपेंसेशन ऑफ 50,000 ऑफ द रुपीज. दिस इज कॉल्ड द गारंटी ऑफ द इंडेमनिटी. as a person, as the promiser, I have to fulfill my guarantee. I have to pay the specific amount, and that is called the guarantee of the indemnity, which is described under section 124 of the Indian Contract Act. Okay. So this chapter 8 speaks about the indemnity and guarantee. I just described you what is indemnity, and this is explained from section this is explained from section 124 to 147 of the Indian Contract Act. Okay, 124 to 147, around 20 plus sections. This part is been described. So we are going to discuss about the indemnity and guarantee, this chapter 8, in the next class in a detailed manner. This is all for today, guys. We can wrap the class over here. See you all in the next class. Thank you. Bye bye. Take care.